Good morning, everyone. And on behalf of our firm and our team, would like to welcome you to today's program. I'm Adam Griffin, joined today by my colleagues David Katz and Roy Hadley to talk to you about a very timely topic about ransomware attacks and the implications that those can have on entities. This is what we're going to talk about broadly today. I'm going to start and lead us off here talking about the current state of ransomware and related attacks, and then transition to the risks and the effects of those, which David will cover, and then Roy will talk about questions, things that people should be doing now. So let's get right into it, talk about the current state of ransomware and cyber attacks. Part of our job is to raise awareness about these issues to our clients and to others, to talk about what we're seeing in the field, talk about the incidents we're handling. That part of our job has certainly been easier lately. No doubt everybody's heard about Colonial Pipeline, and I'm going to talk a little bit about that today. If you're not intimately familiar, Colonial Pipeline was attacked by criminals. The criminals demanded a ransom to get back access to their data and systems. There were impacts on fuel supplies and things far outside just that one company. Ultimately, the company paid the ransom, reportedly around $4.4 million. In talking to our clients and others about that, a lot of people have been shocked at the amount that was paid and that the ransom was paid. And I want to share with you all that that's really not exceptional, either the amount that was paid or that it was paid. In the scheme of things and in the ransoms that are sought and the amount of this activity that's going on, it's a small fraction. So this one made the news, but there are a lot of others that do not. And it came out recently that CNA, which is an insurance company, they paid $40 million in their ransomware attack back in March. That one's certainly the largest that I've heard of, but even other attacks in the millions of dollars and payments in the millions of dollars are not unheard of. Just this month, JBS, which is the world's largest meat processor, paid an $11 million ransom, and we can keep going. There have been other ransoms in excess of $4 million that perhaps people have not heard about. There have been many more than that as well. And these anecdotal incidents are indicative of a larger trend that we and others have seen. Ransomware costs have risen, and the amount of ransomware attacks have also risen. So you see here the damages and the cost of those over a short period of time has increased dramatically. And there's a couple things that are driving that. So I want to talk about those briefly. Two primary drivers are ransomware as a service and the rise of the double ransom. Let's start with ransomware as a service. It's essentially a business model for internet criminals, and these are criminals and they're highly organized. So the group that was involved in the Colonial attack is called DarkSide. Their model looks something like this. DarkSide makes the malware, the software, the tools needed by criminals to perpetrate these attacks. DarkSide makes that and then essentially licenses that software, that malware, to affiliate groups, other criminal groups, who then attack victims. And in exchange, DarkSide takes a cut. It's not always clear exactly what the cut is, but it's a pretty substantial cut in some instances of the millions of dollars that are paid. So you've probably heard of software as a service. This is now ransomware as a service. So what that means is that criminal groups that perhaps lack the sophistication to develop, really cutting-edge malware, they don't need to do that anymore. They can just license it from somebody else. So just like you may license your email service from Microsoft and use Office 365 instead of creating your own Office suite, they can just hire someone to do the software part for them. That has made it more accessible to more people, and it has made it so groups don't have to have that sophistication. More people can perpetrate more ransomware attacks. The other thing that's happened is the rise of the double ransom. So really, even a year or 2 years ago, ransomware attacks were fairly straightforward. You had software that was installed on your systems, and you couldn't get back access to those systems. All your files were encrypted until you paid the ransom. But what happened is that a lot of people got really good at recovering from that. People's backups got better. People were air gapping their backups. And so if all of their files were encrypted and a ransom was demanded, they would just restore from backup and tell the criminals, no, we're not paying. So the criminals' revenue went down. And being enterprising criminals, they needed to get their revenue back up. So they opened a new line of business, which was the double ransom. So before they encrypt all your files on your systems, they steal personal, confidential, other sensitive information. When you discover the ransom, they say, you have to pay a ransom to get back your systems and what you have locally to get the key to unencrypt that. But, oh, by the way, you have to pay another ransom or we're going to release all your information on the internet. And so that has put companies in a real bind. With the double ransom, the backups are only going to get you part of the way there. Your backups, you may be able to restore your local systems from backup and continue to operate, but all your customer or other sensitive information may be released on the dark web. It is generally not a wise idea to call their bluff on that. We have seen instances where the criminals have actually released that information. So unless you're comfortable with it being released, a lot of people have had to pay that ransom. That has really driven the cost significantly because people don't have a lot of options. That's what's happening. Those are the biggest drivers. And I want to talk also briefly about one other thing that happened with regards to Colonial. And this is not a trend. This is very much the exception to the rule. This is exceedingly rare. But in the Colonial Pipeline attack, the FBI was able to recover $2.3 million of the $4.4 paid. We don't know all the details around this right now, but it appears that some of the funds went to a Bitcoin wallet that the FBI had the private key to. No one really knows how they got that private key, but the FBI was able to then recover the funds from that account. It's possible that the 2.3 they got was the cut that was being paid to DarkSide. It's possible it was somebody else's cut. It's not clear right now why all that happened. But another takeaway here, and you'll see reported in the news anytime there's a ransom payment that it was made by anonymous cryptocurrency through Bitcoin. It's anonymous. The idea that Bitcoin is anonymous is not always true. Bitcoin can be tracked, and the wallet addresses for some criminal groups are known by law enforcement. And the public ledger, that shows every transaction, is available online. Actually, anyone can go online. There are various websites where you can go track and look at Bitcoin transactions and transfers. You can search by the wallet address and see how much money comes in and out of it. So Bitcoin, and part of the way that it works, that I'm not going to get into today, is that it is necessarily public what money is moving where. The identity of the wallet holder can be a challenge to discern, but seeing the money move is not an issue. As I mentioned, this is not a trend. This is not something we're seeing a lot of, recoveries by the federal government. But it is hopeful that this is something that will happen more. And perhaps if law enforcement can recover more money, the criminals will move on to other things. But in the meantime, this is an epidemic, and it continues basically unabated. And so with that in mind, and bearing in mind that you cannot rely on the federal government to recover your ransom paid or to otherwise restore your systems, I'm going to turn it over to David, who's going to talk about the risks that directors and C-suite executives face when these attacks do occur.
Thank you so much, Adam. It's great to be with everyone this morning, and thank you so much for joining us. I want to give you just a very quick overview of my portion of the presentation. We're going to talk through 7 slides. I'm going to give you an overview of the business judgment rule, and then we're going to talk about the evolution of how director liability is evolving and what we see in the future by going through 4 cases. And then we're going to talk about the board action that we recommend you take in order to enable some defensibility around your decision making. So as I'm sharing this first slide, I'm going to go through a little brief history of the evolution of what is the business judgment rule. Because traditionally, directors have enjoyed tremendous protection from liability based on the business judgment rule. And as we're going through this, I'd like you to look at the major questions about cyber risk and board decision making and think about how those are going to interplay as the law has evolved. So just to run through these very quickly, these are the kinds of things that need to be part of your decision making and in your mind in terms of assessing what the risk is for liability. So at what point does the board's failure to address some of these risks, take you over the line into gross negligence or gross deviation? And what should directors be doing? And we'll talk about that a little bit later in the presentation. Then how many of these red flags, how many events would it take to flip the concern here to be a place of having failed to exercise due care? How can you identify these red flags? Does it have to be when all your systems are encrypted and there's panic? What's the board's duty to oversee these risks? And what are the processes that can demonstrate defensibility in your decision-making by the board? What does it take to fulfill the duty of care, loyalty, and to be acting on an informed basis? And how do you avoid engaging negligent acts or omissions in performing your oversight? So even just kind of going through those questions in light of Adam's portion of the presentation, you can already see developing that there's real risk here and there are real issues to think about long before there's a ransomware attack or any other kind of attack. So just to give you an idea of how director liability works and sort of the evolution, the business judgment rule is a rule that was designed to ensure that good faith decisions are being made by the directors and that those directors are protected, even though in retrospect, the decisions later prove to be unsound, incorrect, or erroneous. But when directors have fulfilled both their duty of care and their duty of loyalty in reaching decisions on corporate actions, directors are insulated from personal liability by the presumptive defense of the business judgment rule, so that they were acting in the best interest of the corporation. And that's been the standard for a very long time. The rule requires analysis of the process by which these decisions were made, rather than looking at the substantive decisions themselves. And the protection under the rule requires that the board decision have a rational business purpose, and the decision must be arrived at in accordance with the fiduciary duties of care and loyalty. Those are the two watchwords, care and loyalty, and must not be objectively irrational and must not cause the corporation to engage in activities that would pierce the protection of having a corporation, ultra-virus activities. So again, decisions have to be independent, made in good faith, and with due care. And the rule presumes that in making business decisions, the directors have acted on an informed basis, in good faith, and the honest belief that such action was taken in the best interest of the corporation. So unless one of those elements is rebutted, the court really looks to see whether the business decision that was made was rational in the sense of being on a logical approach to advancing the corporation's objectives. And if the directors can demonstrate that they fulfilled these elements of the duties of care and loyalty, then a court will not sit in judgment of the director's decisions that bear negative consequences. But the business judgment rule does not protect for failures to act when action was warranted, and it does not protect directors for insufficient adherence to their duty of care or duty of loyalty in authorizing actions that ultimately resulted in harm. So in the duty of care column is where this case that we've seen a line of cases over the last 2 years. The Caremark case is the case in 1996 that really introduced this concept about how is a director exercising their duty of care? What does oversight really look like? So Caremark introduced this concept of red flags to director oversight. The board cannot satisfy obligation to monitor activities without assuring information and reporting systems that exist and that are reasonably designed to provide senior management and the board itself timely and accurate information sufficient to allow management and the board, each within its scope, to reach informed judgments concerning compliance with law and business performance. So now we've got some element to the duty of care to really understand it in a little bit more in depth. So Caremark articulates the necessary conditions that are a predicate for establishing director oversight liability. And again, it's assuring information and accurate reporting systems that are designed to provide timely and accurate information. So in cases where the directors have failed to implement in reporting or information system controls, or having implemented such systems or controls, they consciously fail to monitor or oversee operations, thus disabling themselves from being informed of risks or problems requiring their attention is when liability can arise. So if you look at this in the cyber context, and we're about to get into these cases, you can see if you understand just by the current environment, by the nature of what's going on in the world, that you should have put in some kind of system to control those risks and monitored those systems where you were aware of those risks, where you had a duty of care to make sure that the company was taking care of shareholders and exercising business judgment in a rational way, consistent with that duty of care, then you have a problem if you can't meet that standard and you're exposed to liability. So I'm going to run you through some of the cases that have evolved over the last 2 years that have involved this Caremark standard, some in the cyber liability context, but others in another context that illustrate the importance of the duty of care and the fragility of the duty of care in the context of some of these cases. And I think it's going to be clear to you that there's a roadmap here for exposure on the cyber liability side that I think is more prevalent, more relevant, and more of a risk than at any time in the future, just by virtue of the fact that it's in the news every day and it's attracting a lot of attention. So this first case that we're going to talk about is Marshawn versus Barr. And once you hear the facts, you're going to say to yourself, well, wow, that's fairly obvious. So this case involved Bluebell Creameries. This is a 2015 case that suffered a listeria outbreak, causing the company to recall all of its products, shutting down production at all of its plants, and to lay off over a third of its workforce, as well as creating a liquidity crisis that forced the company to accept a dilutive private equity investment. As a result, the shareholders brought a derivative suit against two executives at Bluebell's directors, alleging breach of fiduciary duties. Specifically, the complaint alleged that the executives, Paul Cruz, the president and CEO, and Greg Bridges, the vice president of operations, breached their duties of care and loyalty by knowingly disregarding contamination risks and failing to oversee the safety of Bluebell's food-making operations, and that the directors breached their duty of loyalty under Caremark. So stepping back for a minute, you're producing ice cream and you have no internal plan to address food safety. That was where the court really began to focus and say, is that consistent with the duty of care? So on appeal, the Supreme Court of Delaware acknowledged that our case law gives deference to boards and has dismissed Caremark cases even when illegal or harmful company activities escape detection, when the plaintiffs have been unable to plead that the board failed to make the required good faith effort to put reasonable compliance and reporting systems in place. The court found that the complaint supported an inference that no system of board-level compliance and monitoring and reporting existed at Bluebell. They made ice cream, the ice cream had listeria, and people got sick. Very basic kind of concept in a business, serving food, creating food. They would have some program in place to make sure the food wouldn't make people sick. And you can very easily apply that analogy if you're dealing in massive amounts of information or even small amounts of information. If that's your core business, and you've got no process in place to protect it in cases where it could damage your shareholders. Specifically, the court found in Marshawn that there was no board committee that addressed food safety. It didn't exist. There was no regular process or protocols that required management to keep the board apprised on a regular basis, such as quarterly or biannually, or any key food safety risks, during a key period that led up to the death of 3 customers. Management received reports, what could be considered red, yellow flags, and the board minutes of the relevant period revealed no evidence that these were disclosed to the board. The board was given certain favorable information about food safety by management, but not important reports that presented a much different picture of the board meetings, were devoid of any suggestion that there was any regular discussion of food safety issues. So in sum, the court held there that when a plaintiff can plead interference, that a board has undertaken no efforts to make sure it is informed of compliance issues intrinsically critical to the company's business operation, then that supports an inference that the board has not made a good faith effort that Caremark requires. So again, attacking that duty of loyalty. And in the realm of cybersecurity issues, the Marshawn case may be especially instructive regarding how and whether a board may rely on information they receive and how and whether to validate such information as part of effective oversight. So the next case involves FDA approval on involving a drug a therapeutic drug. So in Clovis Oncology, an emerging biopharmaceutical company was developing a therapy for the treatment of lung cancer. The drug was promising in its early stages, but it became apparent toward the later stages of clinical trials that it wouldn't be approved by the FDA. As a result, the Clovis stockholders alleged that members of the Clovis board of directors breached their fiduciary duties by failing to oversee the drug's clinical trial and then allowing the company to mislead the market regarding the efficacy. In addressing the Caremark claims, the Delaware court stated in the Supreme Court's recent decision in Marshawn underscores the importance of a board's oversight function when the company is operating in the midst of mission-critical regulatory compliance risk. So again, that's very critical for businesses that are bound by a regulatory perspective, by law, to maintain and secure data. The court further acknowledged that, as Marshawn makes clear, when a company operates in an environment where externally imposed regulations govern its mission-critical operations, the board oversight function must be more rigorously exercised. And while Caremark does not demand omniscience, it requires that a good faith effort to implement an oversight system and then monitor it, including sensitivity to compliance issues that are intrinsically critical to the company. So again, it's not demanding that you have to be aware of and manage every single risk, but you have to have a good faith effort to implement an oversight system and monitor it. And that's really what can bring you defensibility. With respect to the first Caremark prong, the court held it would be difficult to conceive of how plaintiffs would prove that the board had no reporting or information security, information system or controls. However, the court held Clovis failed the second Caremark prong. Having implemented a system of controls, the board consciously failed to monitor or oversee its operations. So if those controls are in place and you've got no indication that you're monitoring them or that you're responding when they're triggers or alerts, that can also get you in a lot of trouble. So the second case that we're going to talk about, and there's one more after this, so we're moving through this material. A Chinese-based search engine provider, Baidu Inc., alleged that the service representative of Register Inc., a domain name registrar, allowed an intruder to change Baidu's email address on file after failing to compare the intruder's inaccurate security code to the real code. The intruder accessed the account, routed internet traffic to a rogue site, and caused a 2-day business disruption. It caused Baidu millions of dollars. Baidu pled specific factual allegations in support of a claim of gross negligence based on the defendant's failure to comply with their own security requirements. And the failure included processing the intruder's request to change an authorized email address despite receiving an incorrect response to the security question, not checking the intruder's bogus security code against the correct code, failing to question the legitimacy of the intruder's new email address, and providing the intruder with the plaintiff's username. The Southern District of New York held that Register's alleged failure to follow its security protocols was sufficient to plead grossly negligent or reckless conduct. And this is just an attacker that got in using a fake password that wasn't detected. This liability standard contained within the parties' service agreement is substantially the same as gross negligence standard governing board liability. Register was potentially liable because while it had adequate security controls, it failed to follow them. So the final case that we're going to talk about, and we're going to get to some specific recommendations, is Transeo versus Bessemer Venture Partners. In this case, a shareholder filed a derivative claim against the president, CEO, and director of a software company who allegedly relocated the company's web services, associated IP, and cache from France to the US. This disrupted the company's services, comprised client security, facilitated hacking of his website, and violated European data protection laws. Judge Kathy Siebel held that a claim for breach of duty of loyalty based on the failure to act in good faith was adequately pled under Delaware law. And although this case did not identify the data privacy laws violated, it's a useful warning in the developing area of litigation. If a director intentionally violates the law or causes the company to do so, he violates his fiduciary duty. And finally, in this case, there was efforts to locate the cash and assets from France to the United States, and that even this relocation violated European data protection laws. Plaintiffs were able to plausibly allege that the CEO in this case directly and knowingly falsified business records and relocated cash and assets. So another kind of element to this, apart from duty of care. But so what is a board to do to establish some defensibility in light of what we've seen in those cases, and the fact that the Caremark standard really provides an opening to be challenging whether or not the boards have exercised the proper level of care? So again, in this slide, what we're trying to recommend here are some of the things that could allow you to remain defensible and be able to demonstrate that you have exercised your duty of care. So very clearly delineating cybersecurity oversight committee, outlining those responsibilities, making sure there's a good record of the oversight and development, implementation of the information security program with specific responsibility assigned to executives and officers that are accountable to management of the board, having good corporate policies to mitigate risk, recruiting an independent director with cybersecurity credentials. That's one that you haven't typically seen, but having somebody on the board that's familiar with these issues and can speak to these issues is an element of defensibility that you can bring to the argument that you weren't exercising your duty of care. And then educating board members as part of the formalized quarterly education program about emerging risks. So I want to thank you for your attention. That's my portion of the presentation, and I'm going to turn it over to Roy.
Thank you, David, and thank you, Adam, for just really great knowledge and great information with respect to board liability, culpability under case law, and with respect to, you know, kind of just what the threats are. And as Adam said, the threats are here. They're morphing. The whole double ransom thing where they're stealing data in addition to locking up your files is one of those things that is nefarious at best. And, you know, I think we will see more of those sorts of things. So with that said, you know, you're on the board or you're advised the board, you're in the C-suite, the board is asking you for recommendations. And so the questions that you should be asking are what we're going to talk about next. If you're on the board, what should you be thinking about? What should you be asking of your management team? And that's what we're going to talk about here for a few minutes. You know, first, we have to say, do you understand the threats? Do you really understand the threats that face your business, that face your organization, that face your industry? I think Colonial Pipelines is a good example of that. You know, if you look at their incident response plan, or you look at things that you know, they were concerned about before, cybersecurity probably wasn't one of them. They probably were thinking more along the lines of natural disasters, you know, supply disruptions, things like that. But now you have to ask the question of, you know, do we really fully understand the risk from a cybersecurity standpoint and in information management that face our business? That's question number one. Question number two is when you start thinking about how you plan and your incident response plans and your business continuity plans and things like that, particularly your breach response plan or your incident response plan from a cyber standpoint, is it based on a known framework? So those frameworks, things like NIST, or if you're in the Defense Department supply chain, CMMC, or DFARS, you know, a lot of acronyms there, but make sure that whatever you're doing is based on known frameworks, because those frameworks have been tested, they've been researched, they've been vetted, and they are a very good starting standpoint. So that's really question number two. You know, is our program based upon a known security framework? Very important. The third thing that, you know, you need to ask yourself is look around your board. Do we have cyber security expertise on our board? You know, gone are the days where you could look at it and say, okay, the CIO comes make a presentation and we're good to go. You need to have expertise on your board. And, you know, some of the things that David talked about with respect to the duty of care, arguably you're not exercising your duty of care if you don't have some sort of legitimate cybersecurity expertise on your board. Now, that may be an independent board director, or you may bring special help on to help the board to understand these issues and these questions, but you need to have that independent expertise on your board in order to say that you're fulfilling your duties with respect to cybersecurity. Kind of following on to that, the next question is going to be, have you identified somebody in charge, a senior person in charge that has the full backing of the board and of senior management? So you need to have somebody that, you can point to and say, this person is responsible. And that's always important from a management standpoint, because, you can do a lot of things by committee, but when things start flying, the bullets start flying, you need to have somebody on board to make sure that, you are knowing who to talk to and knowing the point person. And a lot of breach responses that we've dealt with, it's critically important. And sometimes we're put into that position where we're the person, but you need to have that person already identified at your company. The next question is going to be, has management really formulated a plan around cybersecurity? I often talk about a holistic approach to cybersecurity. And when you look at these questions that we're asking in this part of the presentation, all of these kind of flow to that holistic thought around cybersecurity. From a board standpoint, again, you need to be making sure that senior management is looking at this thing. So they're not just looking at A, B, C, or D. They're looking at all of them, and they're looking at how they relate to your cybersecurity program. And as we said in that first question, how it relates to your business, how it relates to your industry, and the threats that are facing your industry. These threats are evolving. Like you said, like Adam said, you look at Colonial Pipelines, you look at JBJ, meat packing and manufacturing, and those are typical industries, especially the meat packing, where you would not think that cybersecurity would be of particular concern. But as we can see, it is of the utmost importance, because almost all businesses run on technology now. I would venture to say all do, and a cyber incident can shut down your business and have catastrophic consequences. So from a board oversight standpoint, you need to be asking that question. The next question that we will, that you should be thinking about is, again, have you, and this kind of goes back to the first one, have we aligned our business and cybersecurity strategies? We've kind of talked about that, but you just need to make sure that senior management is aligning those strategies and that they are complementary to each other. Gone are the days where you could say technology was over here and business operations were over there. They are together now, and so you really need to be thinking about that. The next one is always a tricky topic, and that is budget. Have you provided, and has senior management provided, an adequate budget to address cybersecurity preparedness and response? Business, you always are prioritizing, you're always, taking from here and there and trying to keep those expenses down. Unfortunately, due to the threats that are facing business nowadays, cybersecurity and the budgets around that really have to kind of go to the forefront. And that's going to be particularly important if, for some reason, an incident occurs or litigation ensues around it, because what you don't want is a situation where you've made conscious decisions not to adequately fund cybersecurity and an incident happens because of shortcomings in budget. So always be mindful of the budget. Again, you have to operate all aspects of your business. You have to prioritize, but I would argue that you need to pay particular concern and attention to those budget requests that are coming out of your IT department or from your CIO or your CISO, if you have them, with respect to cybersecurity and cybersecurity initiatives. The next one is, and David kind of alluded to this, is, are you really looking at third parties? Is management looking at third parties? That supply chain is going to be critical to your cybersecurity posture. So if your vendors are not adequately prepared from a cybersecurity standpoint, regardless of what you have done, you're not adequately prepared. So you really need, from a board standpoint, to make sure that senior management is looking at your third-party vendors, particularly those critical vendors for your product, your service, your supply chain. I know in the CMMC world, which is the Cybersecurity Maturity Model Certification, which is in the Defense Department supply chain, that's one of the things that they are really kind of focusing on, and that is making sure that downstream vendors are also certified and have adequate cybersecurity posture. So even though CMMC won't apply to the vast majority of people listening to this webinar, the concept of making sure your suppliers, so even if you're in an educational setting or something like that, making sure that those vendors that you use for online services, online teaching platforms, web-based platforms, making sure they have adequate cybersecurity protocols in place, because if they go down, you go down. So just something to think about. Another thing that as a board member you need to be thinking about is, does senior management have in place adequate methods to address ongoing changes in laws and regulations? And again, regardless of what industry you're in, educational included, healthcare, doesn't really matter. The laws and the regulations are changing. For example, many states are starting to look at, if they haven't already adopted them, increased privacy laws. You see California, kind of a mini GDPR, which is the European data governance regulation, basically giving consumers more rights around their data. Does your company, has senior management put in place a framework to understand these, to know about them, and then to adequately and appropriately address them? So you need to make sure that senior management has a method for addressing changes in laws and regulations. And I know that a lot of these seem very cumbersome, but these are the kinds of questions that you need to be asking senior management of your organization. Cyber insurance is one. If you don't have it, do you need it? Can you get it? One thing that we found is that the cyber insurance market is really tightening up. And so gone are the days where you could just automatically get it. Insurance companies are starting to demand better cybersecurity postures. We're starting to see in the renewal market where companies are getting less coverage for 2-3 times the premium that they used to enjoy. So a lot of these questions that you're asking and the answers, the appropriate answers, let's just say, will put you in a better position to get cyber insurance, better rates and those sorts of things and coverage, but it will also put your organization in a much better posture from a cybersecurity standpoint. Kind of getting towards the end of the questions here, going to the last kind of 5, and these are going to be really critical ones. And the first one is, is your organization prepared to respond to an attack? It's not a question nowadays of whether something will happen or if it will happen. It's just a question of when it will happen. Your organization will be impacted by some sort of cyber incident if it hasn't already been done or so, and if it has, it will be impacted again. That's just a fact of life nowadays. So are you adequately prepared? And so what does that mean? The first thing it means is, does your organization have an incident response plan in place, a written incident response plan, one that has been tested? And so if you don't, you need to have an incident response plan, and management needs to make sure that that is in place. The second thing of being prepared is going to be, do you have a business continuity plan in place? Two different things. and again, that business continuity plan needs to be written and it needs to be thoroughly tested. You can't put these things, go out, hire somebody, draft a plan, and never test that plan. You've got to make sure that that plan is appropriate for your industry, for your business, for the risk that you're facing, and that it has been tested, and everybody that has a part in that plan knows about it and knows what their roles are. So that's, kind of the second thing that you need to be thinking about. And again, you have to test these things. It used to be that we would say you test them once a year, probably at least twice a year is a good thing, a tabletop exercise or, that sort of thing. And if you don't know what those are, we can help with those. And then the last one that I'm really going to talk about is training. Do you or does management have a training program in place? What we have found in incident responses is more often than not, there's a human element that caused the problem. Somebody clicked on a link. Somebody went to a website and did something that they weren't supposed to do. And so you can have all of the technology things in place that you want to have or need to have in place, but if you don't adequately train your people, then it's all for naught. And what does adequately training? They need to understand the threats, they need to understand their roles, and it needs to be constantly reinforced. So, one might argue that some type of monthly reinforcement, online training or in-person training, something needs to happen with respect to everybody in your organization. Because again, gone are the days where you can just say, yeah, we did our annual cybersecurity training and that be enough. The threats are evolving, the threats are constant. And so your training and your holistic approach to cybersecurity and cybersecurity preparedness from a director standpoint needs to be right up there every day, top of mind. And then the last question that we'll ask is probably the most important. So we talked about all these questions that you as a director should be asking, but the most important thing is going to be, do you have the ability to understand the answers? Can you understand the answers that are being told to you with respect to those questions? One of the questions, if you recall, was, do we have adequate cybersecurity expertise on the board? And if you don't, you need to bring in somebody that can help answer those questions and help you as a director to understand those questions, understand what those answers are, so that you can then understand what more you need to do to fulfill your duties as a director with respect to cybersecurity. So a lot of questions there, a lot of discussion, but all of these are going to be very valid questions that you need to be thinking about, asking and understanding the answer so that you can make sure that your organization that you are a director for is adequately prepared from a cybersecurity standpoint. So the next kind of area that we're going to talk about is just kind of what should you be doing now, given all of that, given that, what Adam said about these constant evolving threats, given what David talked about with respect to your duties of care and the, kind of how case law is evolving right now, and given what I talked about with respect to the questions that you should be asking as a director, what should you be doing now? So I'm going to turn it over to Adam here to just kind of talk about some of the action items that you should be thinking about right now. Adam?
Thanks, Roy. The first thing is to actually ask those questions, right? To ask the questions that Roy mentioned. It's important to follow through with that and to learn and gather as much information as you can. There are also some things you can do to mitigate your risk and to see if your organization is doing these things. Roy mentioned training. Training, I think, with the rise of the double ransom has become number one importance, and building, what's called the human firewall. You can buy the most expensive computers and devices and endpoint protection products. And if you have an employee that clicks on a phishing link in an email and enters their credentials, all that's going to be for naught. So using phishing campaigns and training is important. Encrypting your files, both at rest and in transit. Encrypted data stolen by attackers may not be able to be read, and it may be difficult for them to double ransom you. Backups still are important. There's other things like multi-factor authentication, monitoring, technical things that your vendors and in-house people can help you with. But it's important to see how many of those things you're doing, and you can always do more. More from a policy standpoint, the incident response planning is critical, as Roy mentioned, not just putting the plan in place, but practicing it. I always use a football analogy. No team has their playbook and waits until game day to run through those plays. You practice, you refine, you get better. It's very important to do those tabletop exercises and practice your response plan. A comprehensive written information security program. This is required by law in some places and circumstances. And as part of that, classifying your data from importance to least importance, from sensitivity, and implementing the principle of least privilege, which means only the people who absolutely need access to that data get access to it. Not everyone has access to everything. That way, if you have one person that makes a mistake, you can hopefully limit the scope of the damage from that. Another important thing to consider: data retention and destruction policies. The less data you have, the less risk you have. That's just a necessary logical fact. So to the extent you can purge data, that's prudent. One thing we've noticed in a lot of the breaches we've handled, if not all, is that our countries are shocked at the scope of data that they held. And they didn't find out how much data they had until they had the breach. And that's not what you want to happen. We mentioned earlier cyber insurance. It's not often that lawyers make absolute statements. They're usually qualified by something like probably or maybe or depending on. I think this is one I'm comfortable at least making an absolute statement that everybody needs cyber insurance. But bear in mind that not all policies are created equal. There are not really standard forms out there. I have a 2-foot-tall stack of all the cyber policies I've read. There are sublimits, exclusions, definitions that may not match what we would normally use. So it's important to really read and understand that, or have someone who does understand it, and to know that you can't just say, oh, we've bought insurance, that box is checked. Look at your limits. Look at structuring it with an excess policy. More insurance. People ask me, how much cyber insurance should I buy? I don't need to know how much you have. The answer is more. Buy as much as you can. Right. So with that in mind. And
Adam, one thing that I'll just throw in there, with respect to cyber that you were talking about, and that is renewals are becoming more difficult. And so even though you may have gotten cyber insurance in the past and had a program, renewals are becoming more difficult, and the forms that the companies are using, the exclusions are changing. And so what I would suggest is, like Adam said, you need cyber insurance. That's almost an absolute, for 2 reasons. One, it helps to protect the risk, but 2, it also helps you to get better from a cyber preparedness standpoint, because you're going to have to jump through more hoops and hurdles to get that coverage. But just understand that when you renew, just because you may renew with the same company, what you pay and what you get very well might be drastically different. So you need to keep a sharp eye with respect to that in your cyber insurance programs and renewals.
Right. Those applications have gone from 1 to 2 pages a few years ago to 6 to 10 pages now. So be prepared to be asked a lot of questions. And when you're marking no, we're not doing that, I always think about that premium just ticked up a little bit. So the more yeses you faithfully answer, hopefully the lower your premium. David's now going to talk a little bit about more about the managing the vendor and third-party risk.
Yeah, one of the very important things that I think everybody on this call should understand is in the 50-state data breach notification statutes that require you to notify any individual that's been the victim of a cybersecurity attack that's had their personal information exposed, you have the obligation as the data owner to make that notification. And if you're outsourcing your information, your customer, your consumer information to a third party that is not the data owner or the licensor of that data, the only obligation that that third party has under the law is to tell you that your information, your consumer information, has been breached. So your third-party vendor that you've outsourced your IT to, you've outsourced other responsibilities in terms of processing and managing data, if they're hacked, their only obligation under the law is to tell you, hey, I'm sorry, your information was obtained. You have to go out and notify the consumers that we were responsible for managing. And the cure to that, the way around that, is through the agreement, the contract that you're negotiating with these third parties. And we spend a lot of time in our practice looking at an outsourced agreement, software as service, another kind of vendor agreement where the vendor's engaged with some kind of data processing, and making sure that agreement has specific provisions that make that vendor more responsible in the event that there's a breach. And that includes making sure that vendor doesn't cap their liability at fees, that there are exceptions to the limitations of liability in those agreements in the case of a breach, because there are going to be costs related to notification and investigation. And so there are many elements in these agreements that you need to be adding in to what is typically the boilerplate language of the vendor, and really going on the offensive in these agreements and making sure that these risks are properly accounted for and outlined, and that you have a good contract, a secure agreement that addresses things that would otherwise not be clear. So that's a major component of managing risk when it comes to third parties that are handling information on behalf of your company. Thanks, Adam.
And one final note, if you do suspect you have a ransomware attack or some other breach or incident, do not delay. Get your counsel involved. Get experts involved. Typically, your forensic and recovery vendors are going to be hired and retained and coordinated through counsel. We have a 24/7 hotline that's available that's answered by an attorney that can assist with those issues. So encourage you, even if you suspect something, to get those wheels in motion. Often time is really of the essence.
Right.
That was our program today. We've had a few questions, some of which I believe have been answered.
Before we hit the questions, the one thing I would say to the people on the call is two things. One is kind of the data breach hotline, and as you said, make sure you know what you're going to do before you need to do it. So know who to call. Know what you would do when bullets start flying before the bullets actually start flying. And then the second thing is take the information that we kind of given today, and a lot of this stuff needs to be thought about and addressed before something happens. We can be eminently helpful in a breach situation by just reaching out to us, but we can also be eminently helpful beforehand in making sure that your resilience is better, that your cybersecurity posture is better for your organization. So, the time to call us is, beforehand. We can help tremendously, but should something unfortunate happen, we can absolutely help on the back end too.
Adam, I see a question in the chat box that I think is a good one that I'd like to address. We've been asked, you described a board member with cybersecurity credentials or expertise. Can you define cybersecurity credentials or expertise that qualify for that level of credibility for a board member? And the marquee certification for information privacy and data security professionals is called a Certified Information Systems Security Professional, CISSP. And so that is the marquee certification. It's very difficult to get. It takes a lot of education. So somebody with experience in a company that has that title and that certification really understands the control frameworks and the technical components that are required to secure an organization and where there might be gaps and how to close those gaps. The other person that would be critical if you could obtain them, many people are familiar with Sarbanes-Oxley and the kinds of auditing that has to occur around financial reporting controls. And over the last 10 years, there's been a tremendous amount of individuals within the industry that are doing the same type of audit work, but around privacy and data security controls. So somebody who's at a Big 10 accounting firm or has that kind of consulting background and credentials, somebody who preferably under direction of counsel could go through an organization and identify or be presented with the control frameworks and where there are gaps that have already been audited. That person could be very valuable to have on a board. Somebody with that type of experience that can say, you know, what I've seen in my practice is they're closing these gaps. We have these gaps. That presents a very clear risk. So those two people could be very critical to having on your board. And somebody else may have comment on that.
I think that's right, David. Those are excellent points.
Agreed. And seeing no further questions, we'd like to thank you all for joining us. There will be a recording made available. The slides are also available. The contact information for all of us is included in the beginning. Feel free to reach out if anybody had any follow-up questions, things you didn't want to ask in this format. And would thank you all again for joining us today.
Absolutely. Thank you.